Greetings to the friends of the law offices of Brent Williams-Ruth. I am Brent Williams-Ruth, and I'm coming to you today, June 20th, 2023, with an educational moment. Now, first, I will give a disclaimer that this educational moment is meant to be purely that. This is not advice specifically to you, except for the places where I will say this is advice. It's also given under the auspice that I am a licensed attorney in the state of Washington, and therefore, if you are not in the state of Washington and you're watching this, please take this with a grain of salt and consult your own legal advisors in your own home jurisdiction. All right, we're going to talk it. Lisa Marie Presely. She passed away suddenly of cardiac arrest at the age of 53. Wasn't planning on dying, like most people. And then it came out. There was a 2016 amendment to her document, her estate planning documents, specifically her trust, that controls the estate of Elvis Aaron Presley. And it had some legs. Number one, whenever my clients come in and we're signing estate planning documents, I tell them, sign as you normally would sign. Even though I have written and it's printed there your full legal name, I want you to sign your regular signature. Lisa Marie, allegedly, if she actually did sign this trust amendment, did not sign her normal signature. In fact, her name was spelled wrong, which gives rise to a second potential issue, because in Washington state, testamentary documents such as a will or a trust can be challenged for just a handful of reasons. Number one, fraud. You didn't actually sign it. Somebody else signed it. Number two, you lacked capacity to sign those documents, because in order to create a power of attorney, a trust, a will, there must be a certain level of mental capacity in order to do so. There are a couple other reasons. Undue influence or duress. Somebody is forcing you to do it. Again, hard to prove, but it has been done. And those cases are pretty fascinating to read the fact pattern of an undue influence or duress case. But here with Lisa Marie, you have one, the potential for fraud, because also it was not witnessed or notarized. So did she really do this? Did she do it in a moment of capacity where she spelled her own name wrong? Now, I will say, my mom gave me a middle name that's spelled uniquely. And for many, many years, I was not spelling my own middle name right. But Lisa Marie Presely was 53 years old. You would think she would know how to spell her name, unless there was some capacity issues. So that's what came out in the beginning. And it has now been settled for an undisclosed amount between Priscilla Presley, her mom, who was challenged, who had filed this will contest, and her granddaughter, Riley, who was Lisa Marie's sole beneficiary of her document. Oh, boy, Alberto. This is where I always encourage and have a free update policy. My clients who are part of the concierge estate planning relationship are allowed to contact me at no cost in the future to make adjustments to their documents, because I never want them to have a dispute that says what is or is not covered. Now, what are some things that you can do on your own to avoid this from ever being an issue for yourself? Number one, never write on your original will or trust. Just don't do it. Don't make notes in the margins. Don't cross anything out, because that right there can lead to the creation of an ambiguity that can impact the administration of your estate. And again, if you're in a jurisdiction that has specific formation requirements, that change, if you've changed something and if you've crossed something out, but it wasn't actually witnessed and notarized in Washington, if this was a will, then it's not a valid change. But now it's created this again, ambiguity for potential challenges for the administration. So just don't ever write on an original document. If you want to make a change, make the change, have it done properly in your jurisdiction, and that way there'll be no questions asked. Now, again, for my clients, I always just tell them, call me, we take care of it. So many changes are open the Word document, backspace, 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 type in a new name, add a new provision, remove a provision that may have been there that's no longer necessary, save it, print it. There we go. We have a new signing appointment, which is really fast because you don't need to review everything. I just point out the one thing that's changed. Now, I also want to talk about changes through codicil. Yes, yes, yes. In the traditional legal world where you're being billed every single penny, a codicil is a cheap way to make an adjustment. However, there's no central repository. There's no database that says, oh, hey, Brent just made a change to his will, and now there's a single-page codicil that amends and changes some documents in his original will. If family members or somebody else doesn't like what's in that codicil, but has no problem with the original will, that codicil can disappear, but there's still a valid will. How would you even know that there was a codicil? You don't. So that's why with my clients, rather than doing amendment on amendment on an amendment with 15 different codicils over the years, I simply re-execute a brand new will that this one supersedes everything else. Because in my wills, it says page 1 of 15, page 2 of 15. It's all initialed each way. Because for me, when dealing with estate planning, the most important thing that I'm dealing with is making sure that there's going to be a lawfully enforceable document that leaves no question for ambiguity, no question as to what the intent of the testator, the person who created the document, wanted. So again, I always feel bad for families where this arises because who knows? I mean, there are reports that Lisa Marie and her mom Priscilla had some falling outs over the years. So maybe Lisa Marie really did want to remove Priscilla from having any control over her estate as the business manager. And here's the thing. When you make changes to your documents, there's no requirement that you tell anyone you've made changes until after you've died. But when there are questions to the formation and proper execution, that leads to what we just saw. And now, if you believe the reports that came out this week, that there's a settlement in which Priscilla is going to receive a hefty amount of money, some are even speculating into the millions, to have her assume a special advisor role where Riley is still the trustee and that will then manage the entire Pressley estate now. But Priscilla still is getting some money that she'll be able to live on. But again, all of this can be avoided when working with your attorney. And if you are working with an attorney where you're afraid of being nickeled and dimed and you're in the state of Washington, please call my office. Again, my free update policy is one that my entire firm was founded on 8 years ago. Because an update really doesn't take more than 5-10 minutes. We talk about it, we do it, we sign it, we get together, we have a little catch up. It's not something that you should avoid using proper channels because you're afraid there's going to be a cost. Because in my firm, there is no cost to me. There you go. If you or anyone you know is interested in estate planning in the state of Washington and would like to talk to my office, give a call, 253-285-7751. We're happy to talk with you. Consultations are always on the house. And I hope you're having a great day. Take care. And remember, do not ever write on original documents.